I think I am now live. Welcome, everyone. Thank you for joining me. My name is Lior Samfiru. I am the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP, and you are here for your employment law session, your live employment law session, when you get to find out all the information you need about your workplace rights. This is a live session, a Q&A session where you get to ask questions, I get to answer them, and that's how this works. So again, I'm Lior Samfiru with Samfiru Tumarkin LLP. Our firm, you can find us across Ontario, BC, and Alberta. So if you're in one of those three provinces, we can give you legal information. You can get some answers. You can find out what the law does, what the law says, and what to know about those very important legal rights that you have. You have rights. You have rights if you lost your job. You have rights if your boss is mistreating you. You have rights if your hours have changed, your job has changed, your compensation. You have rights if you've been discriminated against. I think you get the idea. You have all sorts of rights across Canada when it comes to your employment law situation. Too many people don't understand what their rights are. Too many people assume that the law can't do anything for them. That's wrong. And I'm going to prove that to you today, as I always do when I answer your questions. So you're live, I'm live. You can type in your question, hit enter. I'll see it and I'll read it and I'll answer it. Now, let me give you some additional contact information before we get started. To connect with me and my team, very, very easy to do. Okay, to connect with me and my team, all you have to do is go to employmentlawyer.ca. You see that address on the screen below, employmentlawyer.ca. When you go there, not only can you contact me, you have the phone number there, the email address is there, not just for me, my whole team across Canada, but you can also read more about employment law, about rights, get frequently asked questions. I host a radio show and a TV show. You can get the schedule for that if you want to learn more about rights. I think you get the idea. It's your one-stop shop for everything and anything employment law. But right now, I'm live. Okay, so I'm not just here in a recorded session. I'm here actually live talking to you, wanting to answer your questions about employment law and workplace rights. Don't worry about asking bad questions. There's no bad questions. There's only answers. There's solutions. There are things that you can do. Again, I'm Lior Samfiru, the employment lawyer. Let's get started answering some questions. But as you listen to me, ask your question. Don't regret later that, man, I wish I had asked Lior a question and now the session is over. I'm here. Take advantage. Ask your question. Again, Lior Samfiru, Samfiru Tumarkin LLP. This is your live employment law session. Let's see. Our first question today comes from Ben. I have been a part-time employee with the company for 5 years. I have requested vacation time, an additional 2 weeks of unpaid leave. The Human Resources sent me a letter which gives them the right to reconsider my employment upon my return, and they cannot guarantee that my position will still be available. They also mentioned that I'm not entitled to severance. Can you please advise what I should do or sign this letter? So an employer is not required to give you leave when you ask for it, unless it's for specific reasons, which I'm going to get to. So if you say, well, I need some leave, I want to do some personal stuff, or I want to, I'm moving, so I need the leave of absence, your employer is not required to approve that. So if they don't approve it, if you leave, you're potentially losing your job. You can be considered to have abandoned your job, and then you may not have a job to come back to. Now, that's different than vacation. If your employer has approved your vacation, you take your vacation. But if your employer has not approved your vacation, or you used up your vacation and you want to take additional leave, your employer is not required to say yes. Now, something else, though, that you want to keep in mind. There are situations where your employer has to give you a leave. I'll give you a couple examples. For example, if there's a medical reason. So if you're sick, if you're unable to work, and you have a doctor's note, your employer has to allow you the time off, whether it's a week, 2 weeks, a month, a year, whatever it is, your employer has to give you that time off, and you don't lose your job just because you took the leave. Another example is a situation where you have a very sick family member, a parent, a child, and you have to provide care for that family member. Your employer may be required to give you a period of time where you can be off work and your job is still there, guaranteed for you. So there are a couple of situations, and every province is a bit different. But in most cases, if you just want to take a leave and your employer says no, you can't do it, or you risk losing your job. So Ben, hopefully that makes sense. Any follow-up questions, any issues, any problems, you know what to do. Reach me, my team. through employmentlawyer.ca. Again, employmentlawyer.ca, the place to go and the way to do it. All right. I'm going to continue answering questions. By the way, if you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin, and I am here live with you. I want to see more questions coming in. I've had a busy few weeks with lots of questions. I want another busy week today with many questions to answer. So don't be bashful. If you're watching me, fantastic. Ask the question. That's even better. But right now, I'm going to continue answering questions. And our next question today is from Facebook, and this is from Simon. Our company is being taken over, and we have been offered new employment contracts that do not recognize any of our work history. If we do not sign, are we owed severance? Yeah, you may well be owed severance in this situation if you do not sign, but I want to see that employment agreement. In many cases, if you refuse to sign a bad employment agreement with your new owners, you're going to be terminated and you get your full severance. But I want to see that agreement first. So before you say no, before you walk away, let me see that, because it's not every situation that would allow you to get severance. So we want to review that very carefully. But generally speaking, if you're offered a very unfavorable agreement and one that doesn't recognize your past service when they should be, is one of those, then yeah, if you refuse, you lose your job, you are going to be owed your severance. So I want to see that agreement before you do anything. Employmentlawyer.ca, again, employmentlawyer.ca to connect with me and get that done. So please make sure you do the right thing, Simon, before you do anything else. All right, fantastic question. Thank you for joining. Lior Samfiru, that's me, the employment lawyer. Let's get more questions answered. See how easy it is? You can do the same thing. Peter has our next question. Peter asks, if you go on medical leave from a job, can you then get employed by a different employer? Employer A is the cause of the medical leave. Well, so I guess I want to understand, are you planning on going back to employer A? If you're just not going to go back, then you don't even need a medical leave. You just go find another job. But if you're thinking at some point to go back, yeah, you can get another job so long as your doctor says that you cannot work for company A, but you're okay to work for company B. Now, once company A finds out about the fact that you're working for company B, they may get very upset and they may try to fire you, but that would be illegal, okay? But you need to have that doctor's note. It makes perfect sense that, I can't work in this job. My doctor says I can't, but I can work in the other one. That's fine. But if you know you're not coming back to company A, then who cares, right? It doesn't matter at that point. Hopefully that makes sense, Peter. Now, if they let you go, I want you to connect with me immediately, because you're going to be owed severance. Potentially, there's other damages as well. So to connect with me, Peter, if that happens, employmentlawyer.ca. Again, employmentlawyer.ca, right there on the screen right there. So now you know. If you have a follow-up question, if something I said makes no sense or it's not clear, I'm still here. You have plenty of time. Ask your question, and you shall have an answer. All right, fantastic question. Thank you very much for that. If you've just joined us, again, thank you for joining us. This is your live employment law session. I'm Lior Samfiru, the employment lawyer, and I'm answering questions. Let's get your question answered as well. And next question up on the docket here is from Terry. I recently requested to take my 2 week of paid vacation and an additional 2 weeks of unpaid leave. Oh, I think we answered that one. No, I think we've answered that question, or a very similar question. Okay, Peter says, thank you. So you're very welcome, Peter. Now, as we wait for the next question, let me kind of talk to you about situations where you may actually lose your job without realizing it. We know, of course, that there's times when your employer lets you go. So you're going to know if the company lets you go. But there's other times when the company doesn't say that. They're not telling you they're letting you go, but the law considers you to be terminated. Okay? And an example of that is a situation where you're put on a temporary layoff. Now, if you're put on a temporary layoff, your employer is not saying we're letting you go. In fact, they're saying we're not letting you go. We're just going to put you on a temporary layoff. We'll call you back down the road, but not so fast. The law was going to come in and say, no, because that temporary layoff in most cases is not legal, you, the employee, can consider yourself as being terminated. And now you get severance. We call that constructive dismissal. So no, an employer for non-unionized employees, in most cases, does not have a right to put someone on a temporary layoff. And if they do, that employee can choose not to accept that and consider that to be a termination and get severance. So that's just one example of being terminated without actually your employer telling you you're being terminated. All right, I'm going to continue answering questions. More have just come in. You have time, plenty of time still to get your question answered. So ask it right now and I'll answer it. Let's see. The next question from Kim. I was terminated today stating it was due to frustration of contract. I was on a back to work plan working 24 hours per week. And the insurance company was paying for the other 11 hours. The insurance company has approved this for the next 6 months. My employer argued that I'm not capable of doing my job and might owed anything. So yeah, absolutely. If you've been working 24 hours per week, that clearly means your employer is able to accommodate you. So how can they say it's frustration of contract comes when in a situation where you cannot be accommodated, then you'll never be able to do your job. But we know your employer is able to accommodate because they've been doing it. So how can they say, oh my God, that's impossible when they're doing it? So what you're looking at here, number one, is a wrongful dismissal because you're owed severance. Number two, potentially a human rights violation because under human rights law, they have the obligation to accommodate you. They can't say we don't want to. They can't say, oh, it's just too much work. No, that is illegal. That's a breach of human rights laws. So Kim, wrongful dismissal, human rights violation, you got to call me. Okay, let's deal with that properly. You're going to connect with me, and I want you to do that today through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me and my team and making sure we'll make sure that you get what you're owed. Not right. If your employer can accommodate you, they must accommodate you. All right. Okay, Michael has a question. My investigation is being handled by the enforcement supervisor. I don't know what we're talking about. I don't know which investigation, which enforcement supervisor, what happened. I have no clue what we're talking about, Michael. Sorry. Let's see. Peter has a follow-up question. Would there be any issue with the employer would there be any issue with the employer continuing to pay for my medical and dental benefits? So if you're on the leave from that employer, no, they can continue paying for those benefits unless you have benefits with a new employer. But here's what I would do. If you know you're not coming back to that employer, don't play that game. Okay? Just leave the job. If you're hoping to come back once you are able to, that's different. But if you know you're not coming back, don't do that. Because if you take another job and you never come back, they'll say that you knew you were not coming back, you took advantage. They may take legal action against you, so don't do that. But if you're hoping to come back to work at some point, then that's okay, no issue. So I hope that makes sense, Peter. I don't want you to be in any trouble. All right. By the way, if you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And as I've been doing for the last 15 minutes or so, is I've been answering employment law questions from you, questions that you have about your workplace rights. And I want to continue doing that for the next 15 minutes or so. Still have plenty of time then. Be that second voice on this session by asking your question. All right. Next question today from Stephen. I was harassed, mistreated, and underwent discrimination at the workplace after working for 17 years. I'm near retirement on LTD due to depression and anxiety. I want settlement instead of LTD. Well, I mean, I can't do that for you on this live stream, Stephen. You'd have to call me at the office so we can have a private discussion and a consultation. I want to find out how you were harassed, who did the harassment, what did you do about it? Did you tell the company about it? How did they respond, etc.? You may absolutely have a case for human rights violation, for constructive dismissal. So all those things we have to assess. So obviously we can't do that on this live stream. So the next step, connect with me as soon as possible through employmentlawyer.ca. I'll give that to you again, employmentlawyer.ca. Place to go, phone numbers there, email addresses there. All the information you need to reach out is right there. Again, employmentlawyer.ca. All right, great questions today, guys. Let's get some more in. I'm Lior Samfiru, of course, the employment lawyer, and I'm going to take Clara's question next. Clara has a question. I worked as an administrative assistant for a family-owned company for 9 months and was let go suddenly. I had never received any discipline or negative feedback. I was told it was due to restructuring. I was not asked to sign anything and was only given 1 week severance. What are my options? So the issue here, Claire, is not the fact that they let you go or the fact that you were obviously a good employee and they let you go despite the fact you were a good employee. An employer is allowed to let go an employee pretty much at any time as long as they pay proper severance. So really the issue is the 1 week severance that you got enough? And the answer is no, not even close. Now, I don't believe you gave me your age, but I know you've been there in an administrative role for 9 months. Depending on your age, you could be owed anywhere from 2 to 6 months of severance, 2 to 6 months, not weeks. So they give you 1 week. That's a lot less than that. So that's likely and potentially a wrongful dismissal. Obviously, we have to review your employment agreement as well. So, Clara, I want to remind you and everyone else that short service employees, Clara's only worked for 9 months, get disproportionately more severance than longer service employees. All right? So you may have only worked for a few months. Your severance is going to be measured in months, not days, not weeks. So you have to keep that in mind. It's very easy to think, well, I only worked there for 9 months. I get a week's pay, maybe 2 if I'm lucky. No, it could be 3, 4, 5, 6 months, even more in some cases. So that's why you always call me. I don't care if you work for a few months, a few years, many years, you always call me. Now, before I move on to the next question, I want to give you another tool that you can use to find out how much severance you are owed, whether you work for a few months or for many years. All you do is you use our severance calculator. You can find that at pocketemploymentlawyer.ca. You see that address right there on the screen, pocketemploymentlawyer.ca. And when you go there, easy, you can find the severance calculator. You click on it, you use it, 3 questions or so, and you get your answer. You find out how much severance you're owed. You'd be surprised. So many people think, oh, I get a week per year of service, or I get 2 weeks per year of service. No, wrong, false, not even close. Check out pocketemploymentlawyer.ca, use the severance calculator, find out how much you really owe, the real amount. You'll be shocked. And by the way, if you want to, you can connect with me directly from the severance calculator. So again, pocketemploymentlawyer.ca. All right, but right now I'm still live, Lior Samfiru. That's me, the employment lawyer. Let's continue answering questions. You still have time, by the way, to get your question answered. So what are you waiting for? Let's do it. Our next question comes from M. Knight. Hi, Lior. My friend got fired a few weeks ago. They offered him 26 weeks plus 8 weeks for over 27 years of service. The termination letter didn't mention it's for cause. So guess what? He's probably owed about 2 years, 24 months. They offered him 34 weeks. That's a third of what he's owed. All right. So no, that's not even close to being appropriate. He needs to contact me as soon as possible. You did the right thing, of course, by asking the question here on the live stream. But the next step that you have to do is you have to get your friend to contact me as soon as possible. He or she can contact me through employmentlawyer.ca. Again, employmentlawyer.ca. You see the phone number there, email address is there, and we'll do what we do, which is to get the severance that your friend is owed. Massive difference between 34 weeks and 24 months. We're obviously talking tens of thousands of dollars that your friend is owed. So we know what to do. You know what to do. Employmentlawyer.ca. By the way, your friend can also use the severance calculator that I mentioned. You find that at pocketemploymentlawyer.ca. And I'll help your friend. Okay. So thank you for connecting with me, M. Knight. But next step, let's get this done all the way. Have your friend reach out through employmentlawyer.ca. So let's see. Next question. Right now, by the way, you have time to answer yours. Saga World Boss. How long do you have to be laid off to get a severance package? well, if you're laid off, you can get your severance package. There's no time limit on that. Okay, so maybe I misunderstood, but if you lost your job, whether it's you lost it permanently, or even if you've been put on a temporary layoff, yes, you're owed severance, and you can contact me. Happy to help. Happy to make sure you get what you're owed. Let's see. All right, some more questions coming in. I love that. So M. Knight, so just so you understand, my team, we have a team of about 48, 50 lawyers right now, some of the best lawyers in the country, okay? Whether you speak to me or any one of my colleagues, my partners, my associates, you and your friend are in the best hands ever. So you don't have to worry about it. Call us. They'll schedule you with the most appropriate lawyer to make sure that your matter gets moved quickly and on good terms. That's all you need to do, okay? Don't worry about anything else. All right, let's see. Next question from K-Rocks. Love the name. K-Rocks has a question. My employer's vacation policies have recently changed, and I lost over 50 vacation days. Wow. We used to have the option to roll over our unused vacation days with no limitation. This was recently changed to 5 days maximum per year, and my unused vacation days were removed from our vacation tracking system. Is this allowed? Should I have been compensated for these days? Yes. So if you've been allowed to do that, and that was a term of employment, your employer can't just take it away. It's essentially money that's yours, that you're owed. So yes, you can claim for that. You can even file a complaint with the Ministry of Labor for that, or reach out to me. But no, that is not proper. That is not legal. And you're, of course, owed much more. All right. Now, I was talking before about situations where you may be terminated without even realizing it, without your employer telling you, but the law considers it a termination. I gave you the example of a temporary layoff. All right, a temporary layoff. Well, there's other examples. One is when your terms of employment have been changed. For example, your hours have been reduced, or your schedule has been changed. Instead of working days, you're working afternoons, or your compensation has been changed. All those things can result in a termination, a constructive dismissal. So remember, if your employer is going to say to you, we're going to change your schedule from 9 to 5, now it's going to be 12 to 8, your employer is not going to say we're letting you go. They're saying, no, we're just changing your hours. But again, not so fast. The law comes in and says, wait a second. By changing the schedule, by making significant changes to those terms of employment, that employee can consider employment as being terminated. Again, that's what a constructive dismissal is. So you, as the employee, you're able to initiate the termination and say, no, I'm not okay with this. I'm not going to take this change in hours or shifts or whatever it is. I'm going to consider that to be a termination and get severance. I'm making that decision as the employee. So you want to keep that in mind. And one of the reasons you want to seriously consider that is this. Let's say your employer changes your schedule from 9 to 5 to 12 to 8. And you think, yeah, okay, I'll still be done by 8 o'clock. It's not so bad, I guess. I'm not happy, but I'll accept it. So you're kind of being the good soldier and you accept it. The problem with doing that is that now you've given the company the right to do it again and again and again. Why? Because you accepted it the first time. So the next time, when instead of 12 to 8, now you're working 5 p.m. till midnight, you won't be able to do anything about it. That wouldn't be a constructive dismissal anymore because you let it happen that first time. So you really want to consider that. Now, I'll say one last thing about this. If you think you're in a constructive dismissal situation, before you march into your employer's office and say, that's it, constructive dismissal, pay me severance, you need to talk to me. Because not every change that's a constructive dismissal. It's not every situation that gives you the right to get severance. So we need to have that discussion. Myself, my team, you can connect with us through employmentlawyer.ca. So be smart, do the right thing. Don't put the cart before the horse, okay? employmentlawyer.ca. All right, still have a few minutes here to get your question answered under the wire. You have some time, ask your question. Please don't disconnect today and not have your question answered. Get those answers right now from me, Lior Samfiru, the employment lawyer. All right, next question is on Facebook from Ellie. If you were signed onto a contract of 2 years and you were let go before the end date, are you owed anything? Well, the general rule is if you signed a fixed term contract, a contract for a specific period of time, and you're let go before that contract ends, the company still has to pay you until the end of the contract. So to use your example, if you signed a 2-year contract, and let's say you were let go a year and a half into that contract, well, there's still 6 months left on it. The company still has to pay you for that 6 months. Now, in many cases, that could be a huge amount. I had a case a few years ago where someone had a 5-year contract they signed, and they were let go 3 or 4 months into it. So they were owed another 4.5 years of pay. So remember, that's how the general law works. Now, we also have to review your employment contract at that point. That what I just said could be changed based on the terms of the employment contract, but the general basic rule is if you're let go before the end of the contract, you still have to get paid for the remaining time of that contract. So thank you for that question, Ellie. If you're let go, I need to talk to you. You need to talk to me, more accurately, at employmentlawyer.ca. All right, let's see. Next question from Gracie Grace. Can you be put on a performance improvement plan without being told? I'm currently on a disability leave and found that I'm apparently on one despite not signing or knowing about it. No, because you can't. Because let's think about it. What is a performance improvement plan? A performance improvement plan, as the name suggests, is a plan that's put in place to help you increase your performance. So how can there be a plan without you knowing about it? It's a super secret plan. No, it doesn't work that way. So it's meaningless. It's useless. Now, all that means is that the company can't use that against you. It doesn't mean that there's a law that strikes it out. It means that it's just meaningless. It's just a piece of paper that does nothing. But if you find out now that you're on a performance improvement plan, stupid as that is, read it. And if you don't agree with it, say so. So generally what I want is this. If you're given negative performance reviews that you don't agree with, or you're put on a performance improvement plan that you don't agree with, you have to respond to it. You have to say in writing why you don't agree. You have to say in writing why it's not accurate, etc. Now, of course, if it's completely accurate and there's no issue, fine. But if it's not accurate, if there's something that's not clear, or if it's something that you don't agree with, you want to say so in writing. You don't have to be very long about it, and always be very polite and professional. You would write to your employer and say, employer, I read this document. Here's why I don't agree with it. Or here's some information that you didn't consider. Put that in there. It's very important. It could make all the difference in the world. All right. So now you know, Gracie Grace. Any questions, you can reach me through employmentlawyer.ca. I'll take one last question here today, and that's from Shane. If an employee works in a unionized workplace, does the collective bargaining agreement take precedence? Yes. So really, if you're in a unionized workplace, it's just a collective agreement that matters. Everything that you heard me say today does not apply in a unionized workplace. Does not apply. The collective agreement applies, and some of the other terms that over the years have been negotiated between the union and the employer. There's no such thing as severance, really, not in the same way. There's no such thing as constructive dismissal, etc. None of that applies in a unionized environment. So if you hear me say something, it doesn't apply in a unionized environment. And last thing I'll say is, if you're a unionized employee and you have a problem or a dispute with your employer, the only one that's allowed to help you is the union. You cannot go to someone like me or another employment lawyer to help you. It has to be the union. So Shane, hopefully that makes sense. Guys, this is the time I have for today. Lots of questions today. Thank you so much for those questions. Always a pleasure to be here with you and to answer questions and to hopefully help you solve some of those workplace issues. Thank you for being with me today. I'll be back, of course, next week, but don't wait until then. If you have an issue, a problem, you want to connect with me and my team, I'll give that to you one more time, employmentlawyer.ca. Again, employmentlawyer.ca. I'm Lior Samfiru. Thank you again, all of you, for joining me. We'll talk to you again soon. All the best. Bye now.